law does not mean implies the implementation rather than grant of power. Number one, it doesn't imply, it implies limitation rather than grant of power. If rule-making power is made subject to legislation, sir, then the rule-making power of Supreme Court will become functus officio. Constitutional grant of rule-making power is construed as a continuing power, sir. So there cannot be any limitations on that, or constitutional power given that. It is not an enabling provision. Subject cannot mean subject to legislation, sir. If subject law is interpreted as Supreme Court's rule-making power are subject to, then that would be a grave violation of independence and separation of powers doctrine, sir. Subject law means substantive law. Subject to law means substantive law as distinguished from pleading and practice. Substantive law includes much more than legislation. It includes common law. Subject to law means rule-making power as to practice must not invade the field of substantive law. So there has to be something existing. It cannot invade the field of substantive law. But it does not give them the power to legislate, sir. And, sir, with your lordship's kind permission, I have prepared.
ये जो existing law था उसके दायरे कार में रहते हुए और कानून
आप rules नहीं बना
रहते हुए power in any event vests in the.
My lord,
it says, now let's read it like this: the Supreme Court may make rules regulating practice and procedure of the court. Your contention is that a high body, as the constitutional body, as the Supreme Court, had to be reminded that there is a constitution in existence. Don't violate it. That's a very strange proposition. No. You are at the council. Yes. Please सुन लेते हैं council को.
I'm also reading it the same way. The Supreme Court may make rules and regulating the practice and procedure of the court, subject to the Constitution and the law. Which means Supreme Court can make rules,
yes,
whatever rules it wants to make.
Ji.
But it can't go beyond
the Constitution or any law which already exists.
So there is
वो मेरा सवाल अपनी जगह ठहरा हुजूर आप जवाब तो दे दीजिए.
My lord, with utmost respect, I'm not reading it
utmost respect को छोड़िए सिर्फ जवाब दे दीजिए.
अच्छा सर, आपके साथ
मेरा वक्त की कमी है.
जी, I know, my lord. I'm just saying that subject to law, subject means some kind of restriction.
मैंने आपसे आप देखें जो मैंने सवाल है उसका तो आप जवाब
मैं आ तो जाऊं उसमें.
नहीं, आप आएंगे तो अगर दिन निकल जाएगा. मैंने कहा अगर ये हम लफ्ज काट दें सब्जेक्ट टू द कॉन्स्टिट्यूशन एंड लॉ, फर्क क्या पड़ेगा फिर?
जी,
ये इसका सवाल का जवाब दे दीजिए.
फर्क नहीं पड़ेगा, लेकिन पॉइंट इज दैट
नहीं पड़ेगा ना.
नहीं, लेकिन
थैंक यू.
इशू
चलिए नेक्स्ट पॉइंट.
नहीं सर, पहले अभी सुन तो ले, मैं कंप्लीट तो कर लूं सर आपकी इजाजत से. अगर फिर भी कोई लॉ आप रूल नहीं बना सकेंगे which violates any provision of the Constitution.
Is this something to be taught to the Supreme Court?
No, sir. But I'm humbly submitting subject to law does not mean the Parliament can legislate. That is my humble submission. Subject to, क्योंकि जहाँ Parliament जहाँ Constitution power देता है Parliament को बना दिया, specific words are used.
नहीं खैर, अब पता नहीं आप redundancy is
I'm not assuming it is. I'm
1, 2, 3, 4, 5, 6 words of the Constitution we can delete as rendered meaningless.
So
I'm reading it like that if I accept your contention.
Subject to only means, my humble submission is that subject to only means that there's some kind of a restricting, because the constitutional power, which is a continuing power, is being given to the Supreme
Court. Noted. Next point.
The point is that the words used in the if Parliament, if Constitution is giving power to the to make any law, it specifically used certain words in the Constitution. If my lord kindly sees 154(5), Article 154(5). Next page. My lord, until Majlis Shura Parliament makes provision by law in this behalf, the Council may make its rules of procedure. These are the words. Then Article 6.3, my lord, if my lord kindly sees Article 6.3. Article
6.3 or 63?
6.3. Article 6, subclause 3. Majlis shall by law. Article 6, my lord.
जी पढ़ लिया
जी. Parliament shall by law provide punishment of persons found guilty of high treason. Then my lord will kindly see 151(2), freedom of trade. And my lord also reads 150, subject to clause 2, trade, commerce, intercourse throughout Pakistan shall be. Majlis-e-Shura may by law impose such restrictions. May by law. Again, sir. Then, my lord,
what is the point you're making?
I'm making.
You're just citing different provisions.
My lord, if the word in the 191 was the parliament can make law, these kind of expressions as provided in the constitution would have been used, my lord. My humble submission is that when the constitution is giving the legislature a power to enact a law, then specifically words are used in the part.
Mr. Zubairi, there's another question.
My lord.
Once the rule-making power has been exercised,
my lord,
by the Supreme Court in terms of the Constitution, because the power vests in the Supreme Court, can subsequent legislation displace, as this Act purports to do so, can subsequent legislation displace the rules that have lawfully been and constitutionally been framed by the Supreme Court?
No, my lord, that's my humble submission. They cannot, for the simple reason, because then it will become ad nauseum. For example, can now the Supreme Court, which excise can make law regulating its practice procedure, make a law overriding the Parliament's making of the law? Then the Parliament will do it. Then where will we stop? So my humble submission is that could not have been the intention of the framers of the Constitution, that to give power to Parliament, because there are separation of power doctrines there. Once the Honorable Supreme Court has made the rules regarding regulating the practice procedure, the Parliament does not. But that practice and procedure, the rules, cannot be in violation of any constitutional provision, any law which existed, sir.
The core question is, where does the Constitution confer, in which institution confer the power to make rules?
Ji.
Whether it is the Parliament or is it the Supreme Court?
Ji.
If it is the Supreme Court, the only restriction is that the Supreme Court can do so within the framework of the Constitution and the existing law.
My lord.
And that's it.
Yes,
the Parliament cannot, because the power does not vest in the Constitution in the Parliament in terms of Article 199.
191, my
lord. Next point.
My humble submission on this score is that's the reason I was saying.
I would really want to hear you, Mr. Zubairi.
Sir, my lord is asking a question.
नहीं वो आप बात तो करें फिर सवाल उठेगा
यकीनन पूछ रहे हैं इसी बात से सवाल उठाए सर जी.
Now, if I may ask you, these words subject to the Constitution, if these words were not there at all, and the Supreme Court were to make rules, and someone were to point out, well, sir, this proposed rule X is contrary to the Constitution, the answer would presumably be, the Supreme Court would say, well, okay, yes, you're right, so we can't make rule X, right? So in that sense, saying subject to the Constitution is always redundant.
Yes.
Because it's always going to be there.
Yeah.
Seems to me, but this is the question, that perhaps there's a more subtle point here. The Constitution, of course, can also be amended. Yes?
Yes,
under article. But by and large, the Constitution is regarded at any given time to be fixed. Right? This is it. Underneath it, whatever happens by the judiciary, by the executive, by the legislature. So maybe the point in saying subject to the Constitution is not to make the obvious point that everything is always subject to the Constitution. Everyone knows that. But rather to fix the position of law, that when the rules are being made, what you just said, when the rules are being made by saying subject to the Constitution and the law can only be as at that time.
At that time, sir, when the rules are framed.
This is the point that is being made here, because otherwise I was thinking about this, and I've been thinking about this since the case started. Why say subject to the Constitution? Because everything is always subject to the Constitution.
Mr. Zubairi, I just want to say one thing. The day we hear this case, the weeks we hear this case, our institution exceeds our disposal. the day we don't, our disposal exceeds our execution. If you think this is a never-ending hearing, this is the last day of the hearing.
My Lord.
Please remember that. You can argue till 11:30, and each one of us may have their views. Let them be expressed in judgments. I want to hear counsel.
Sir, when a
I mean,
question,
if
my Lord,
please continue. We will restrain ourselves. You just continue your argument so we can be enlightened what you want to tell us, and we can record it, and we can either agree with you or disagree with you in our judgments.
sir, my Lord,
Ab aage badhiye, please. Next point.
If a
Please
judge asks me
go
a
on to
question,
the
I have to
next.
respond
Please
to it,
go
sir.
on to the next point.
So my point is that, again, my Lord, that when the law is being given to the Parliament, the
ये तो आप
specific
repeat ना करो ना,
जी,
point
so hence subject to law, and for that I want to take you. I have placed certain case law before Lordship, if my Lord has that.
जी दीजिए,
जी।
दे दिए या देंगे?
ये रखे हुए हैं सर।
पहले से नहीं दिए?
सर दिए हैं, बहुत पहले से दिए हुए रखे हुए हैं।
आज?
नहीं सर, मतलब उन्होंने कहा जब आप आर्ग्यू करेंगे उस वक्त दीजिएगा, मैं तो कब हर रोज लेके आ रहा हूँ सर।
Sorry, this is most unfair. हमने कहा था लोगों को फाइल कर दें।
तो ये केस हम
हाँ, but ठीक है, you are right, we are wrong.
नहीं सर,
we have told everybody to file. हाँ, भी कागज के टुकड़े आ रहे हैं बीच में से। और ये कोई आसान चीज है पढ़ना?
केस लॉ है सर, इसमें।
तो पहले नहीं कर सकते थे फाइल?
जी।
इन दुनिया में ऐसे होता है? या सिर्फ निजाम अदल पाकिस्तान में ऐसा चलेगा? बाकी दुनिया की हम तारीख में बताते हैं ये जरा प्लीज ठहर जाइए ना कि अमेरिका में क्या होता है, विलायत में होता है, आप ये करें अमेरिका विलायत में जाकर के, फिर क्या होगा आपके साथ? वहां तो आप सारे वेस्टर्न ट्रेडिशंस बताते हैं, इस्लामिक ट्रेडिशंस तो बताते नहीं है। अगर कागज के मामले में ठीक है भाई, मेरी मर्जी जब मैं करूं। ये सच अ सीनियर काउंसिल।
My Lord, may I take page 144 of this? Is a case.
या आप हमें प्रोपोजिशन बताएं, पहले प्रोपोजिशन बताया जाता है।
How a subject to law has to be interpreted. That is my.
ठीक है, बता दें केस का नंबर।
Case is page 144 of this booklet, sir.
जी।
Winberry versus Salisbury. It's a case from the American jurisdiction, and they have interpreted this word, what is the meaning of, and their constitution also provided this thing.
Their constitution also permits filing of documents in courts. चलिए खैर, 144.
Sir, this is just a case law which I'm citing.
ये सुप्रीम कोर्ट का
नहीं sir, it is Supreme Court of New Jersey, sir.
अच्छा ठीक है।
जी। My Lord, page 145. If my Lord kindly sees the sixth line from the top.
देखिए वो जरा मुनासिब नहीं लगता है। सुप्रीम कोर्ट ऑफ पाकिस्तान फुल बेंच में, सुप्रीम कोर्ट ऑफ न्यू जर्सी का जरा ठहर तो जाइए ना। हमें हमारा लेवल इतना लो तो ना कर दें। सुप्रीम कोर्ट ऑफ अमेरिका तो बताइए, आप सुप्रीम कोर्ट ऑफ न्यू जर्सी को हम फॉलो करेंगे।
सर मैं सिर्फ बता रहा हूँ कि
हाँ बता दें, ज़बानी बता दें, हम आपकी बात में ज्यादा वजन है बल्कि सुप्रीम कोर्ट ऑफ न्यू जर्सी में।
उनके कॉन्स्टिट्यूशन में इस तरह का लफ्ज नहीं है, लेकिन उनके जो स्टेट्स हैं उनके कॉन्स्टिट्यूशन में इस तरह के लफ्ज हैं। Kindly see, the Supreme Court shall make rules governing the administration of all courts, state, and subject to law the practice and procedure of all such courts. This is the law which they interpreted. And my Lord, it says at para 2 on page 145.
The phrase subject to law.
The phrase subject to law is not only ambiguous but elliptical. No word
what is elliptical mean?
Sir, मतलब कि it is confusing.
बताइए।
जी.
You're reading a word.
जी.
You tell us the meaning of the word.
Continuous, sir. Continuous. No word in the law has more varied meaning than the term law itself. Nor is the phrase subject to crystal clear, for the phrase implies a limitation rather than a grant of power. It is argued by plain subject law means subject to statute or legislation.
It is argued. भी judgment भी नहीं है।
जी आ रहा हूँ sir. If subject, अब नीचे last paragraph, sir. If the subject were to interpret it to mean subject to legislation, it would necessarily follow that once the legislature has passed a statute in conflict with the rule of court, the rule-making power of Supreme Court will become functus officio. For it would intolerable to hold, as has been suggested to us, that after the legislature have passed an act modifying a rule of court, the Supreme Court might in turn adopt a new rule overriding the statute, and so on ad nauseum. And yet, if subject to law means subject to legislation, any other construction of rule-making power would be in conflict with fundamental rule of constitutional constraint that unless the context clearly requires otherwise, a constitutional grant of authority is to be interpreted as a continuing power. My Lord, then the last three lines, page 146. All these...
Page 147 पढ़ लीजिए।
जी हाँ, उसमें आ रहा हूँ।
Page 147 last two lines से पढ़ लीजिए।
जी, बहुत बेहतर।
वही आ रहा है, नीचे आ रहा है.
जी, इसमें फिर सर पेज 146 पे
147 की लास्ट 2 लाइन से पढ़ लीजिए ना, वो आपको थोड़ा सा उसमें जवाब मिल रहा है.
जवाब आ रहा है कि मैं कुछ आपको पॉइंट करना चाह रहा हूँ कि पेज 146 के लास्ट 3 लाइंस देख लीजिए. मैं सिर्फ जो पॉइंट्स हैं उसको आपको दिखा दूंगा सर. It is inconceivable that the people granted continuing power to the courts in all these respects or withheld it with reference to rule making, sir. Then, my lord, page 147.
Last 2 lines.
Okay. If the regime may amend the rules, or it may decide the extent to which the law, division, charge shall excise the powers, functions of other division. It may control the degree to which legal and equitable relief may be granted in any cause. We think it may be safely, and that no such thoughts are ever in the mind of the member of Constitutional Convention or any citizen who voted for the Constitution. Yet, if subject to law means subject to legislation, such results might inevitably follow. The courts, in some of their essential judicial operations, instead of being one of 3 coordinate branches of state government, would have been rendered subservient to the legislature in a fashion never contemplated by any. What then is the meaning of subject to law? The only interpretation of subject law that will not defeat the objective of the people to establish an integrated judicial system which is independent and which will at the same time give rational significance to phrase is to construe it as equivalent of substantive law as distinguished from pleading and practice. The distinction between substantive, which defines our rights and duties, and the law of pleading and practice, or through which such rights and duties are enforced in courts, is a fundamental one that is part of daily thinking of judges. Substantive law includes much more than legislation. It comprehends also the rights and duties which have come down to us through the common law. The phrase subject to law in Article 6 of the Constitution thus serves as a continuous reminder that rule-making power as to practice must not invade the field of substantive law as such. While the courts necessarily make new substantive law through the decision of specific cases in commonwealth, they are not to make substantive law wholesale through the exercise of rule-making power. That is the concept. So subject to law does not give them a power to legislate. It is not subject to legislation. Where it is made subject to legislation, then the Constitution uses the words. Make such as pointed out. ये कई articles हैं Constitution मैंने 154, 150, then 140,
Don't repeat.
240, 241 and 242 के अंदर भी यही लफ्ज हुआ है make by
Mr.
law.
Abid, the law which is in dispute has been made pursuant to Article 175(2).
Yes, I'm coming,
This
sir.
is the power of the
Sir,
judicature.
but utmost
So,
respect.
in the law itself, pursuant to Article 175(2),
Read
with Article
Article
191.
191. Article
We
191.
are making much time on 191. What about Article
I'm coming to that.
175(2)? Because
I'm
no
grateful to
court has jurisdiction unless conferred by the Constitution or the law.
Yes, but 175(2) cannot be read in isolation. That
No,
is the
no,
judgment of
it
this
is,
court.
it is the dedicated to the judicator.
Sir, may I please
So
submit?
power of the court are conferred under Article 175.
Read with Article
Read
142.
with, that is the law that have made under pursuant to 190, read with 191.
Yes,
but
but
the
the-
law has been made pursuant to Article 175.
My lord,
उसको पढ़े ना 2 में आपके वो
जी,
jurisdiction,
जी।
किसी कोर्ट का jurisdiction जो है, that is related and based
इसका
on
मतलब
the
फिर
premise of
जी, बिल्कुल आप
Article
सही कह रहे हैं।
175(2).
My lord, then provincial law भी आपके लिए
कोई
province
भी
बना
है,
सकता
the
है.
courts 175, there
Two.
shall be a Supreme Court of Pakistan, a High
जी.
Court for each province.
And such a
and
court
the
as may
High
be
Court for
established by
Islam.
law. In no court, number
Article 2,
G,
no court
shall
shall
have any jurisdiction save as is or may be conferred on it by constitution by or under any law. That is synonymous. But humble submission is that this honorable court has interpreted when it deals with the Supreme Court, it has to be read with 2 further articles, Article 142A and Entry 55. May I take your lordship to Article 142A?
Yes.
And that is the judgment of this honorable court, sir.
So this article, I don't
It's
understand.
not a standalone article, sir.
It is?
Does, no, with humble submission. That is.
No, you are now reading words into the Constitution.
reading-
No, where does it say it's not a standalone article?
It's because the judgment of the
So you
Supreme
can
Court says
imply
so.
it, but it doesn't say so.
Sir, I'm not saying anything on my own. I based my arguments on case law and I cite a case law on that of this honorable court, what they have said.
I think the whole object of a full court hearing council is being missed. If all we are going to do is keep referring to case law, we are sitting, the full court is sitting. I don't even think you understand the gravity of it. To understand, to learn from counsel.
Yeah.
Refer to this judgment, refer to that judgment. By the plain words of the Constitution, you don't want to read. Then you want to read New Jersey
how-
Supreme Court? Let's read the plain words of the Constitution.
But
Let's hear counsel formulate submissions on that.
My humble-
Then by all means, if there is some ambiguity, we can
My
go
humble
to
submission-
precedent.
My humble submission
You see,
is that
the main rule for constitutional interpretation is that the entire constitution has to be
Read as a whole.
in a context. You cannot pick up one article and just read it in isolation, because there are other articles which either may restrict or enhance that power
Yes.
which exists in
and
one
how that power is to be
particular
exercised. What is the law they are talking about in Article 71, 75(2)? No.
बात कर रहा है मैच में
Only Supreme Court which can make rules under Article 199. High Court and Federal Shariat Court, they are having the same powers.
Sir, 202 of the Constitution gives the power to make rules to the High Court, sir.
And is there any law made for those two courts?
उनके
which
अपना
are
procedural
distinct
laws
from
हैं
the
हाई कोर्ट
Supreme
में,
Court?
and that judgment of a single bench judgment was cited by Mr. Bhandari on the last date, PLD 2021 Lahore, which deals with what is the meaning that rules can be made, but they are no, they have to be read with NT 55 does not apply to them, because that's why the rules of law reforms ordinance की बात की थी.
Parliament has put up clog on the Supreme Court. Why not on High Court and the Federal Shariat Court?
The High Court में है
What were those
202,
special
sir.
reasons to constitute this act?
Sir, 202 kindly be seen. Subject to constitution and law, a High Court may make rules regulating the practice and procedure of court or of any court subordinate to it. So 202 is
203J is the
G.
Federal Shariat Court.
G. 203J.
नहीं, आप माय लॉर्ड का सवाल नहीं समझे. आपका पहले वाले सवाल का जवाब ये था क्योंकि रूल्स बन गए हैं, तो अब सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ इज बीन रेंडर्ड इफेक्टिवली मीनिंगलेस. माय लॉर्ड का सवाल ये है, अगर आपकी ये बात सही है, तो सुप्रीम हाई कोर्ट के कौन से रूल्स और फेडरल शरीयत कोर्ट के कौन से रूल्स बन गए थे, तो ये फिर इसका जवाब क्या होगा? ये मैं इसका जवाब आपने नहीं दिया.
सर, पहले मैं आपकी बात का वो जवाब देता हूं.
नहीं, मैंने सवाल नहीं पूछा, मैं सिर्फ आपको माय लॉर्ड का सवाल बता रहा हूं.
आपने कहा कि अब नहीं, मैं अभी भी कहता हूं, आज आप रूल्स बनाने जाएं, they cannot be in violation of the constitution. Subject, they have to be subject to any substantive
I
law.
can only use one word for it, profound.
जी. But still, आपने ये कहा कि मैं कह रहा हूँ कि जी अब नहीं हो सकता. My lord, rule making power is a continuous power.
ये समझ गए ना, मगर माय
जी.
लॉर्ड का जवाब नहीं दिया आपने.
जी, मैं दे रहा हूँ उस पे सर. इसके अंदर भी जो लॉ उन्होंने बनाया है, that has to be subject to constitution and the law, and that is the interpretation given in the judgment of.
इसके लिए तो कोई
And you see,
legislation नहीं हुई.
the Lahore High Court in a full bench judgment, जब ये क्वेश्चन अराइज हुआ था कि गवर्नमेंट ने भी लेजिस्लेशन कर दी थी और हाई कोर्ट ने रूल्स भी बना दिए थे, the High Court said you cannot do that.
Do that, जी.
Once the power vests in the High Court, the government or the legislature cannot legislate in matters relating to rules, because the rule-making power exclusively vests in the High Court.
जी. So this is, अगर judgment जिस पे आई PLD 2021 Lahore, page 544, and relevant portion is para 61, page 580 onwards, sir. जी.
PLD दोबारा साइटेशन बताइए.
PLD 2021 Lahore, page 544. My lord, para 61.
आपकी बुक में कौन सा हिस्सा है?
Page 580, page 561.
आपकी बुकलेट में कौन सा है?
जी. बुकलेट में नहीं है सर. मेरे नोट्स भी हैं, मैंने अपनी CMA भी दाखिल की हुई है, पर क्योंकि माय लॉर्ड ने पूछा तो इसलिए मैं निकाल के लाया हूँ उनसे. पैरा 61 और बात 202 पहले कोट करते हैं और फिर मैं आई रीड दिस पैराग्राफ सर.
ये पेज 544 आप कह रहे हैं?
580 sir.
ये तो
It starts at page 544 and relevant portion which my lord's observation is at page 580.
सिंगल बेंच का जजमेंट है.
जी.
Why you are citing it before full bench?
तो इसमें इंटरप्रेट हुआ है हाई कोर्ट की पावर्स के ऊपर जो 202 की पावर्स हैं.
होगी.
जी.
सिंगल बेंच का जजमेंट फुल कोर्ट को साइड. फर्क पड़ता है क्यों नहीं पड़ता?
इसमें एक लॉ बना दिया था, अमेंडमेंट लॉ और रूल्स में अमेंडमेंट कर दी थी. That was challenged and that was set aside. Kindly, may I read, with Lordship's kind permission?
You want to?
G. Thus, the High Court have been conferred the constitutional power regarding rules and procedure, which may not only regulate the practice and procedure of a High Court, but also any court subordinate to it. In exercise of this power, HC has made rules entitled High Court Rules and Orders, which contains elaborate procedure to be followed by the court subordinate to it in matters relating to adjudication of cases before civil court. Thus, not only has the High Court been delegated the power of making and amending rules in the first schedule by the court itself, but also by the Constitution by virtue of Article 202. The central question regarding power of High Court has escaped the attention of Government of Punjab while promulgating the amendment ordinance, which impinges upon the powers of Lahore High Court to enact and amend the rules. This proposition being stated for a simple reason that the amendments to by amendment ordinance are made part of the substantive body of the court, not in the rules comprised of first schedule, and almost all of them relate to details of procedure to be followed by civil courts in adjudication of cases, which as numbered has traditionally been part of first schedule. A grossly egregious and anomalous situation has now been created with pits and the procedure introduced by amendment against the amendments made by Lahore High Court, which now run a parallel course. There are serious contradictions between the two processes, which is most cases are irreconciled. Although, I'm reading from the last line, although in such matters considered as is not normally assigned of, but in peculiar circumstances where across-the-board amendments the rules have been made by committee of the High Court, only a few months, Government of Punjab is obligated to have consulted LC for purpose of reconciliation. Also, while a reference to Article 202 of the Constitution has already been made, it also by implication follows that exercise of rule-making powers is constitutional, which resides in the High Court. Therefore, if such power has already been exercised, emerges as an unwritten rule to be followed in all such matters that is of utmost importance concern be held and the government of province. It is not only essential but also to preserve the independence of that is unique situation where judicial legislation is present. So this is the thing, once the constitutional power has been exercised by the court, because these rules made by this court have constitutional backing, this is what the judgments have said, it has constitutional backing. Even the rules under the Supreme Judicial Council, PLD 2021 Supreme Court page 1, page 94 says that though Supreme Judicial Council does not, the law does not permit, allows them to make rules, but they made the rules, Supreme Judicial Council, and those rules have constitutional status.
So, take a look at Article 203E
Ji.
in relation to the Federal Sharia Court.
Ji.
Take a look at Clause 2. 203 capital E, Clause 2.
My Lord. Yes, my Lord. The court shall have power to conduct its proceeding and regulates its procedure in all respect as it deems fit.
This doesn't seem to be regulated by law.
No, it doesn't, sir.
So therefore, does this mean that the rule-making power of the Federal Sharia Court is on a higher pedestal as compared to the Supreme Court or the High Court?
No, my humble submission, both are constitutional powers, sir.
So,
both the Supreme Court, the High Court have been granted.
I'm just coming off from what my learned colleague was asking you about the rule-making power of Federal Sharia Court. If read literally, this would mean that the Federal Sharia Court is put on a pedestal much higher than even the Supreme Court, to which appeals lie from the Federal Sharia Court.
So then there are judgments of this honourable court that if there's a conflict between a substantive provision and provision of the Federal Sharia Court, then those substantive provisions will prevail, sir. So that is also a judgment of this honourable court on this field. That constitutional provision will be higher pedestal than the provisions under the Federal Sharia Court chapter, sir.
Thank you.
Ji, my lord. So my lord, humble submission is that I was coming to that that the jurisdiction aspect, sir. Jurisdiction aspect is that yes, Article 175 gives the Parliament the jurisdiction to make law, but that law has to be read with Article 142A, which I read to your lordship, sir, and entry 55, sir.
Does 191 confer jurisdiction or does it confer power?
I'd say it confers power, sir. Because it says regulated, the most important word is that the rule make it regulate the procedure, the practice and procedure. What is the meaning of regulate?
91 is not a jurisdiction conferring article.
It is conferring power.
Now, my lord, the framers
of the constitutions were clear in their mind that they wanted to confer the legislative power upon the parliament to have a law for the review, but not for the practice and procedure, my lord. And the wisdom might be, the wisdom might be that in review, a right of a party is involved, while practice and procedure is the internal matter of the apex court.
But counsel, review ke upar bhi, there is already a provision in the Practice and Procedure Act, and review ka jo Section 6 aapne padha hai, that relates to a question of procedure. So where the procedure is already provided, and it has been argued with some force that the power to make procedure and rules and procedures vests exclusively with the Supreme Court to the exclusion of any other organ. Then, once that procedure has been provided, another procedure cannot be provided by the Parliament to override that procedure. That is the argument made. What is your answer to that?
My lord, I totally bow before that observation, but my submission is that only to the extent of legislative competence, the Parliament has the domain. The Parliament, in principle, can provide for a law regulating the review, but not the practice and procedure. Otherwise, the term Parliament or Majlis Shura should have been used in 191, which is not the case, my lord. This is my first submission. And Honorable Justice Jamal Khan Mandukhel had...
आप चलिए आप अपना केस आर्ग्यू करें.
My lord, question...
Other point?
Other point is that, my lord, this conferring of domain or competence, legislative competence upon the Majlis Shura, without having a specific item number in the federal legislative list or the substantial part of the constitution, it means we are giving the parliament a power which it did not have, and that has broader implications for the federation and the federal structure, my lord. Lordships would appreciate that father of the nation wanted a federal state, and he wanted autonomy of the federating units. We are, my lords, interwoven in a very delicate and complex relationship. And what guarantees the autonomy of the federating units is the fact that there is a federal legislative list, there is no provincial legislative list, and the concurrent legislative list is gone. So anything which is neither in the federal legislative list nor in the substantive part of the constitution is a provincial matter, my lord. So, if this honorable court gives the parliament the power to act on a subject which may not be there in the federal legislative list or the substantive part of the constitution at the garb of item number 57 and 58, or at the garb of incidental and ancillary powers, it means that the parliament may encroach upon the provincial subjects.
पहले नेक्स्ट पॉइंट, ये तो आर्ग्यूमेंट अजीब सा है. तो आपका कहना है कि 4 सूबे अपने अपने कानून बना सकते हैं.
No, ये नहीं है मेरा.
तो ये आप यही कह रहे हैं?
No, my lord, no, my lord. Residuary matters. There is no provincial legislative list.
हमें पता है ना, इस कानून की बात करें ना.
My lord, it has implications. It has implications, and these are not remote implications. These are immediate implications.
अगला पॉइंट बताएं.
So the submission is, the prime submission pertains to the legislative competence or the legislative incompetence of the federal legislature, my lord. My second submission is that and it was pointed out by Honorable Justice Musarti Lali in the form of a question.
Please, direct argue करिए.
My lord, answers भी दो. Brief मैं time नहीं लूँगा. That apparently, by virtue of the act in question, the office of the Chief Justice has been done away with. It has been abolished for all practical purposes, my lords. And lordships would appreciate that as per definition given by Article 176.
Before you say this, first say which provisions of the constitutions create the office of the Chief Justice, which has been abolished.
My lord, 176 defines the Supreme Court, which says that the Supreme Court shall comprise of the Chief Justice and judges, as many judges as determined by the Parliament or Presidential Act. So the institution stands on two limbs, office of the Chief Justice and judges, my lord.
आपकी अगर ये बात मान ली जाए तो आप कहते हैं कि चीफ जस्टिस और जजेस अलग-अलग नहीं है, एक ही है।
My lord,
और अगर एक ही है तो फिर क्या चीफ जस्टिस अकेले रोस्टर बना सकता है?
My lord, रोस्टर बनाने से पहले मैं एक अर्ज कर लूँ, my lord. We hear that the Chief Justice is senior among equals. While sitting in the judicial capacity,
let's not go over. Point आप बताएं ना.
Point पे आ रहा हूँ, my lord. While sitting in judicial capacity, he is equal among the equals.
आगे बढ़िए.
What makes him senior among equals is administration. Now, what has been done through this?
There are certain powers specifically bestowed on the Chief Justice in the Constitution.
May I refer to them, my lord?
Yes, there's some powers have been specifically bestowed on the Chief Justice.
Thank you, my lord. I'm referring to them. Some of the powers, my lord. Article 183(2).
The specific mention is of Chief Justice.
Seat of the Supreme Court, Clause 2. The Supreme Court may, from time to time, sit in such other places as the Chief Justice of Pakistan, with the approval of the President, may appoint.
This is destructive of your argument. Here, the Chief Justice has been given this power, not the Supreme Court.
Yes, my lord. Yes, my lord. Because it is at the administrative powers. It is the indication that the Chief Justice is the master of the rules. He is a pater familias. This is the first indication.
ये लफ्ज इस्तेमाल हो रहे हैं, मगर ये आइन में नहीं है. केस लॉ में है.
आइन में यह है कि Chief Justice on his own, without any consultation, without any recommendation of the committee, shall appoint the place of sitting.
Correct.
Yes,
because the Constitution says so.
So administratively, the Chief Justice has at least some say. While the impugned act, मैं दूसरे provision पे आता हूँ, my lord.
Benches के हवाले से वकील साहब, with the approval of President.
Yes.
Circuit बनते हैं ना.
Yes.
ये उसके हवाले से. और ये constitutional provision है, इसके लिए rule की जरूरत नहीं.
Yes, my lord. No rule is required.
इसका notification होता है.
Yes, my lord. But under the Constitution.
सिलसिले में नहीं है जो आप बात कर रहे हैं।
तो बेंच बनाने का पावर है, बेंच का पावर विद द अप्रूवल ऑफ प्रेसिडेंट होगा और उसके लिए रूल तो वही अप्लाई होंगे जो ऑलरेडी पहले से रूल इन फोर्स है, ठीक है?
Exactly, my lord, exactly. But now, Article 10, Clause 1, Roman 1, Federal Review Board. Article 10, 1, Roman 1, after the explanation in the bottom.
Article 10 का.
जी हाँ, भी Chief Justice का जिक्र है.
In the case of a person, is that before your lordship? In the case of a person detained under a federal law, a board appointed by the Chief Justice Pakistan and consisting of a chairman and two other persons, each of whom is or has been a judge of the Supreme Court or a High Court. Now, for all practical purposes, this is a bench to be constituted by the Chief Justice of Pakistan, my lord.
This is not bench of the Supreme Court. This is not a bench of the Supreme Court.
Not strict to sensu. But a forum is appointed by the Chief Justice.
We are talking about the bench constitution, composition of the benches of the Supreme Court.
मैं एक अर्ज कर रहा हूँ, जो पॉइंट मैं बता रहा हूँ वो ये है कि under the Constitution, in the administrative matters, the Chief Justice is on the driving seat. Now I'm referring to Article 146(3), 152, 159, Clause 3. This is only for reference. I'm not reading, my lord. 146.3,
Ji.
152 and 159 clause 4.
152.
152 and 159 clause 4. Under these provisions,
152 or 150?
9(4).
Class 4. Ji.
Under these provisions of the Constitution, the Chief Justice is empowered to appoint an arbitrator in certain fiscal matters, in certain disputes, my lord. Now, under the original Constitution, prior to the 22nd Amendment, the Chief Justice was empowered to appoint a caretaker, Chief Election Commissioner, out of the judges of the Supreme Court. Under the original Constitution, prior to the 17th and 18th Amendment, the Chief Justice alone acted as a consultee for appointments in the judicial.
What is the point you're making?
My point is, my lord, that when we say that the Chief Justice is senior among equals, what distinguishes the Chief Justice from the judges? Administration. Otherwise, the Chief Justice would be equal among equals.
Okay, but you are saying that because these specific provisions of the Constitution specifically mention Chief Justice, so by analogy, he has other powers as well. That's what I've understood from your argument.
By analogy, he is the senior among equals.
Okay.
And you see, where there is a power under 191 to frame rules, the rules are for the purposes, administrative purposes. And in addition to the rules, there are constitutional or there are conventions of the court which have invariably been followed since since the 1956 Constitution, and before that the Government of India Act. So those conventions have also acquired the place of rules, or for that matter, the procedure of the court.
Yes, my lord. Article 268(7) is very much clear to that extent, that anything having the force of law has been deemed as law,
Yes,
my lord.
268(7).
268(7), my lord. Now, what this law has done, the law does not say that the Chief Justice, in consultation with the two senior judges, shall constitute a bench. No. Had it been so, it would be least objectionable. What has been done, my lord, that any two of the three may constitute a bench. So the office of the Chief Justice has been converted into that of a senior judge, or the positions of the senior two judges have been converted into quasi-chief justices. This is my submission, my lord. There is no consultation. While concluding the arguments on the previous hearing, your lordship mentioned to the preamble, Article 2, Article 2A, 227, and I'm grateful that your lordship referred to the Grun norm. No consultation is there in this law, my lord. No consultation. And one potential deadlock which I see, not today, say 50 years from now, my lord, the two judges on one side, the Chief Justice on the other side, 50 years from now. The two decide.
Why 50 years from now? Why
My
not
lord,
tomorrow?
Not regarding the incumbent.
चलें आगे बढ़े ना
मैं एक potential.
आप इतना लंबा तमलीग बांध रहे हैं
मैं 5 मिनट में खत्म.
चलिए कह दीजिए
If the two judges are
हाँ ठीक है तो
on
be in a
one side,
minority, big deal.
and the two decide
So what?
that my honorable the Chief Justice, we have established, we have created a roster, and according to that, for the next month, you will do the chamber work.
ठीक
You will not sit on a bench.
ठीक है
So the office of the Chief Justice has been paralyzed, my lord.
Chief Justice can do so himself.
I'm not saying, my lord.
So it implies that Chief Justice can do so, it's okay.
I'm not saying
But
this.
if two senior judges do so, it's wrong.
My lord, there cannot be
या
any.
तो कहें कि कर ही नहीं सकते हैं तो बात खत्म हो
There
गई.
cannot be any Supreme Court without the Chief Justice. This is my point.
We know that because the Constitution
The
says
Constitution says.
Yes.
And that would tantamount to sending the Chief Justice on forced leave. Such like enactment made by a dictator has already been nullified.
तो इसका मतलब ये हुआ कि अगर 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 चीफ जस्टिस के पास पावर हो और वो कहते हैं कि ये दो जजेस जो है ये अगले 1 महीने तक चैम्बर वर्क करेंगे, फिर क्या होगा?
अगर कोई डिफिशिएंसी है रूल्स
अगर
में,
अगर में चले तो अगर ये भी हो सकता है.
अगर डिफिशिएंसी, आई एम नॉट सेइंग, आई एम नॉट गोइंग टू द विजडम ऑफ दिस लॉ, आई एम रेफरिंग टू द पोटेंशियल डेड एंड वी मे गो इनटू.
ठीक.
लर्नड काउंसिल अभी तक आप फ्यूचर का बता रहे हैं. एज द लॉ स्टैंड्स टुडे, हाउ आर यू इनकन्वीनियंस्ड? आपका कौन सा पर्सनल राइट जो है इन्फ्रिंज हुआ है? एंड व्हाट फंडामेंटल राइट आर यू ट्राइंग टू enforce before us?
There goes, that question goes to the maintainability of the petition, my lord. And except for 3, all fundamental rights are subject to law, subject to reasonable restriction imposed by law.
आपसे simple ये
उसी पे आ रहा हूँ, my lord.
either say yes or no. Are you inconvenienced by this law?
Yes.
Has any fundamental right of yours, has it been infringed?
Yes,
and
my
please
lord.
kindly tell us what fundamental right are you trying to enforce?
Yes, my lord. I'm referring to that.
You don't want,
I have the
you
prime
don't want
right.
access to justice to be.
No.
कुछ और infringement बता रहे हैं, बताइए.
Yes, my lord. All fundamental rights except for the dignity of man and forced labor and slavery, all have been subjected to law. Now the law means
The dignity of
validly
the Chief
passed
Justice.
law, validly passed law coming from a competent legislature, that I may not be subjected to a law for which the respective legislature is not competent. This is all fundamental rights are involved, my lord. And the mother of fundamental rights, Article 4.
ये infringement का बताइए ना, कौन सा fundamental right infringe हुआ?
My lord, if the law is maintained without the necessary legislative competence, it means I'm subjected to a law for which the parliament was not competent. So it is going to affect every fundamental right.
ठीक. और कोई point?
Now, furthermore, under the constitution, all judges are equal, my lord.
जब कह चुके हैं
नहीं, आगे बढ़े ना.
मैं आगे बढ़ता हूँ.
अब हमें कोई lecture ना दीजिए, जो law school में देना चाहिए, please.
ठीक है, मैं अपील पे बहुत कुछ कहा जा चुका. मैं सिर्फ एक potential misuse, My lord, under the impugned act, the committee of 3 judges may themselves sit in a bench constituted under Article 184(3). Now the judgment comes and there is an appeal stage. Now the same committee will decide as to who should hear the appeal against our judgment.
So what's wrong with that?
My lord, it amounts to appealing unto Caesar against Caesar. There is a potential conflict of interest. If I would have been a judge, I would have an interest that my judgment is preserved.
When you become a judge, we can look into it.
No. So this.
बस.
And my lord, मैं दो points करता हूँ. As per section 77 of the Act, which says that every case having urgency or where there is a prayer for interim relief shall be fixed within 14 days. Hardly there would be a case in which there is no prayer for interim relief. So
There will be what?
In which there is no prayer for interim relief. Almost every case has a
I think
prayer.
you're mixing up the concept of interim relief with urgency.
The word interim relief has also been
ठीक
used.
है, okay. So
May I read
we
my
can apply a brain, which we do occasionally.
Okay.
And we can determine what is
what is-
urgent and what is not urgent. So what's the big deal about it?
What is objectionable? That the affairs of the apex court have been micromanaged. Even the civil court ordinance, even the CPC doesn't micromanage the affairs of a civil judge. It is in a way contemptuous. It is insulting. Throughout the world, we have phrases like case management, court management. These are the inherent powers. These are always left to the court, let alone the apex court.
Actually, I'll tell you what we did. I've constituted a committee for case management. So I have given my powers already to a case management committee. So you are saying that act of mine is unconstitutional?
No, my
Because only I can do it myself, or the full court can do it.
No, my lord. It is for this honorable court to do case management. Whoever is delegated that function, it is. But the law cannot micromanage those affairs.
Okay. Chaliye, next point.
Now,
Your point is that by enacting this law, a power of micromanagement has been conferred on the Parliament, which would open the door for it to micromanage not only these things, but subsequently any other thing that it needs to interfere with.
yes, my
And
lord.
that would affect the separation of powers and the independence of the judiciary.
Yes, my lord. And in legal philosophy, it is called the slippery slope theory.
Sorry?
Slippery slope.
Slippery slope.
Yes, my lords. Once you are on a slippery slope.
आगे बढ़ें.
Now, concluding my
Learned Counsel, there was a judgment from the Peshawar High Court regarding the
सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत जारी है. सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत जारी है. कोशिश करें कि वकला अपने दलाइल आज मुकम्मल कर लें. आज ही केस खत्म करना चाहते हैं. चीफ जस्टिस काजी फायज ईसा ने फुल कोर्ट समाअत के दौरान ये रिमार्क्स दिए हैं. केस की समाअत पाकिस्तान टेलीविजन बराह रास्त नशर कर रहा है. प्रोसीजर एक्ट केस की समाअत जारी. कोशिश करें कि वकला अपने दलाइल आज मुकम्मल कर लें. आज ही केस खत्म करना चाहते हैं. चीफ जस्टिस काजी फायज ईसा के फुल कोर्ट समाअत के दौरान रिमार्क्स. केस की समाअत पाकिस्तान टेलीविजन से बराह रास्त.
डॉलर की कदर में कमी का सिलसिला जारी. इंटरबैंक में डॉलर ₹1.29 सस्ता हो गया और ₹281.40 पर पहुंच गया. गुज़श्ता हफ्ते कारोबारी रोज के आखिरी दिन डॉलर $282.69 पर बंद हुआ था.
पाकिस्तान में गैर कानूनी तौर पर मुकीम गैर मुल्कियों का इनखला. डेडलाइन में 22 दिन बाकी. गैर कानूनी तौर पर रिहाइश पजीर अफगानियों के वतन वापसी का सिलसिला जारी. मजीद 48 खानदान वतन वापस जा चुके हैं. अपने मुल्क वापसी पर हम मुतमईन हैं और अपनी मर्जी से वापस जा रहे हैं. अफगान मुहाजिरीन